It is June 2026, and if you have recently lost a loved one, you are probably hearing three words over and over again: executor, administrator, and trustee. But do you actually know which one you are? Or, more importantly, do you understand the legal responsibilities and the financial risks that come with that role? Most people believe settling an estate is simply about moving money from point A to point B. But today, that couldn't be further from the truth. Between the 967% increase in probate document fees and the major 2026 inheritance tax reforms affecting businesses and farms, the role of an executor, administrator, or trustee has become far more complex than ever before. In this video, I'll explain exactly what each of these roles means, how they differ, and the three costly mistakes that could leave you personally liable for an estate's debts. Let's begin. First, let's look at the person legally in charge of an estate. In estate law, titles matter. If someone leaves behind a valid will, the person appointed to administer their estate is known as the executor. Their authority comes directly from the will, but before managing assets, they usually need to obtain a grant of probate. If there is no will, a situation known as dying intestate, the law appoints an administrator instead. The administrator must apply for letters of administration before dealing with the estate. Although executors and administrators often perform similar day-to-day tasks, there is one major difference. An executor follows the wishes written in the will. An administrator has no discretion at all. They must follow the government's strict intestacy rules, and those rules can produce heartbreaking outcomes. For example, an unmarried partner or stepchildren may receive absolutely nothing, regardless of what the deceased would have wanted. So, where does a trustee fit into all of this? In many estates, an executor's work ends once assets have been distributed. A trustee's responsibilities can continue for many years, sometimes even decades. A trustee manages assets on behalf of someone else. For example, a life interest trust may allow a surviving spouse to continue living in the family home for the rest of their life, while preserving the property's value for the children in the future. Or a minor trust, where money is held safely until a child reaches a chosen age, such as 21 or 25. From 6 April 2026, trustees also face an important new responsibility. If the estate includes a family business or agricultural land, they must now consider the new £2.5 million limit on agricultural and business property relief. Anything above that threshold could attract a 20% inheritance tax charge. Planning for that liability becomes part of the trustee's legal duty. The 5-step checklist. Whether you're an executor or an administrator, your journey usually follows 5 essential steps. Step 1. Locate the most recent will and confirm that it is valid. Step 2. Prepare a full valuation of every asset. That includes property, bank accounts, investments, personal belongings, and even digital assets. Everything must be valued as of the date of death. Step 3. Apply for probate or letters of administration. For estates worth more than £5,000, the application fee is now £300. Step 4.
Pay every debt and settle all taxes. This includes funeral expenses, mortgages, creditors, and checking whether gifts made during the previous 7 years have inheritance tax implications. Finally, Step 5. Only after every debt, tax, and liability has been settled should the remaining inheritance be distributed to beneficiaries. Personal liability. Now, here's the part most people never hear about. You can become personally liable. If you distribute money before paying outstanding debts or inheritance tax, HMRC or creditors can pursue you personally to recover those funds. That means your own bank account could be at risk. There's another cost that often catches families by surprise. Since November 2025, official sealed copies of probate documents have increased dramatically. The fee rose from just £1.50 to £16 for every certified copy. If an estate requires 10 copies, that's £160 simply for paperwork. Conclusion. Managing an estate in 2026 is no longer just a family favour. It is a legal responsibility with serious financial consequences. If you've been appointed as an executor or find yourself acting as an administrator, don't rely on guesswork. With more than 35 years of experience, I've helped families navigate these exact challenges with confidence. If you'd like to learn more, download my guide, The 7 Estate Planning Mistakes Families Make. And if you'd like personalised advice, book a confidential discovery call through the Inheritance Guru website. Because a will is never just about death. It's about protecting the people and the legacy you love most. Thank you for watching. If you found this video helpful, please like, subscribe, and share it with someone who may need this information. Until next time, take care.